Yes, Shalabh. Please tell us about yourself.
My name is Shalabh Deep Goyal. I belong to Sambhal, Uttar Pradesh. I have completed my LLB in 2021, and then I pursued LLM, which was completed in 2023, and currently I'm pursuing PhD.
क्या रीजन था आपके लॉ करने का एंड व्हाई यू वांट टू बी अ जुडिशियल ऑफिसर?
Ma'am, my father is an advocate, and my uncle is a senior prosecuting officer. So I drive my interest in law from my family.
जैसे आपने बताया आप एकेडमिक्स में भी हैं, तो आपने लिटिगेशन में जाने का क्यों नहीं सोचा? वो आपके लिए ज्यादा lucrative ऑप्शन हो सकता था।
Ma'am, no doubt advocacy is a noble profession, but due to lack of initial financial security and uh, due to initial financial security and because I have more interest in judiciary, I aspire to become the judicial officer. And that is why I want to join judiciary.
आपका एलएलएम का थीसिस डिसर्टेशन टॉपिक क्या रहा?
The changing dimensions of right to freedom of speech and expression in India.
इसके बारे में थोड़ा बता पाएंगे?
Ma'am, this right is given as a human right as well, and it is incorporated under Article 19(1)(a) of Part 3 of the Constitution. This is the most important right because if this right is not available, then it becomes very difficult for a human for a holistic growth. So with the advent of science and technology, the mediums of speech and expression changes. Recently, by the advancement of science and technology and introduction of social media, now social media has given voice to the voiceless people, and it has reached to the rural areas as well. So, what are the repercussions are coming due to due to social media and how people are accessing this right to the social media. This my dissertation topic was on this.
हिकलिन टेस्ट से क्या समझते हैं आप?
Can you please repeat?
हिकलिन टेस्ट जो होता है, इससे क्या समझते हैं
Clean
आप?
test. A clean test, ma'am, is basically deals with decency in order to check the morality, decency and morality of a particular act. It was laid down in Hicklin's case, and that is why it is called Hicklin test. Uh, According to this test, an act is said to be decent or immoral when it corrupts the minds of the society holistically. If it does not, then such act is not immoral.
मॉरलिटी एंड डिसेंसी इन दोनों को कैसे डिफाइन करेंगे? अगर मैं आपसे पूछूं सिंप्लीफाइड तरीके से बताएं इन दोनों वर्ड्स को।
Ma'am, morality is uh, um, basically some morals which are set by the society, which varies from place to place or time to time. But decency is individual, which a person should be maintained when such person is in public or at private place. Uh, it varies from person to person.
हाँ, बेल इज रूल, जेल इज एक्सेप्शन। इस टर्म का मीनिंग बताएंगे मुझे, और ये किस केस में बोला गया था?
Ma'am, it was said by the High Court, said by the Honorable Supreme Court in Motiram versus Union of India case. Bail is a rule and jail is an exception means since Article 21 is the very crucial right, and in order to balance the powers of the investigating authority and the individual liberty, the law on bail has been laid down. Bail means in exceptional circumstances, the person should be kept behind the bar during the continuation of the investigation. Otherwise, such person must be released on bail. His individual liberty must not be compromised in order to give more power to the investigating authorities.
आप मुझे जुरिस्डिक्शन बता सकते हैं, सीपीसी और सीआरपीसी? दोनों ही प्रोसीजर लॉज में।
jurisdiction मैम in respect to subject matter और
जो jurisdictions को डिफाइन किया गया है सीपीसी और सीआरपीसी में, इन दोनों ही jurisdictions के बारे में बता सकते हैं क्या क्या jurisdictions हैं?
मैम jurisdiction basically is a power of the court to try the case. It is of three types, basically pecuniary, subject matter, and territorial jurisdiction. So the pecuniary jurisdiction is deal under section 6 of CPC. The subject matter jurisdiction is covered under section 9 of CPC, and section 16 to 20 deals with the territorial jurisdiction. In case of CRPC, the subject matter of the courts in criminal cases is the offenses committed in their within their jurisdiction. Uh, Section 177 to 189 of Code of Criminal Procedure deals with the jurisdiction of the courts in relation to inquiry or trial.
शलभ, थोड़ा सा इंटरव्यू को अपन आपके डिसर्टेशन की तरफ लेके चलते हैं। ठीक है, आपने डिसर्टेशन में हाइपोथेसिस क्या रखा था एलएलएम के डिसर्टेशन में?
The hypothesis was that the present laws are sufficient to curb the fake news on the social media.
सफिशिएंट टू कर्ब
The fake news.
फेक न्यूज। फेक न्यूज के रिस्पेक्ट में मेरे को ये बताइए, अभी रिसेंटली फेक न्यूज के रिस्पेक्ट में गवर्नमेंट का थोड़ा सा इन्वॉल्वमेंट रहा, जिसको लेके प्रोटेस्ट भी हुआ था। न्यूज चैनल्स एंड जो आपके एंकर्स रहते हैं वो भी काफी ज्यादा वेहेमेंटली अपोज कर रहे थे। वो क्या मैटर था?
Sir, the government of India introduced an amendment in IT rules through which the government established a fact check unit. And mm, in fact check unit, the government was the only arbiter to decide which news is fake or which news is not. So this was challenged before various high courts, and recently Bombay High Court laid down the constitutionality of such amendment. The Bombay High Court said that the term fake news is very vague, and since the government is the only arbiter and there is no separate mechanism uh, to decide the fake news, the Bombay High Court declared the amendment to the IT rules was unconstitutional and violative of Article 19(1)(e).
शलभ, थोड़ा सा ही बताइए, जब हम आर्टिकल 14 के रिस्पेक्ट में बात करते हैं, देयर वी से दैट वन इज डॉक्ट्रिन ऑफ रीजनेबल क्लासिफिकेशन, बट दैट इज एन ओल्डर डॉक्ट्रिन एंड दैट डज नॉट मीन कि आर्टिकल 14 रीजनेबल क्लासिफिकेशन के इर्द गिर्द ही घूमता है। देयर आर अदर रूल्स एज वेल। तो व्हाट इज अ न्यू डॉक्ट्रिन दैट वी फॉलो इन deciding the constitutional validity with respect to equality?
The latest doctrine in relation to decide the right in relation to decide the equality before law, the it is laid down in EP Royapa case, which is arbitrariness. If even though the law is reasonably classified, but it shows the arbitrariness of the legislation of the legislature or parliament, then it may be declared unconstitutional and violative of Article 1.
Can you state some examples to make us understand as to what do you mean by arbitrariness?
Arbitrariness means a non-application of mind. Uh, for example, recently the Honorable Supreme Court declared the electoral bond scheme unconstitutional because it 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 protects the identity of the donors which used to donate the money to the political parties. There was no reason behind protecting the identity of the donors, and it was decided arbitrarily. Similarly, there was an upper limit of the turnover to which a company could donate, that was removed, and there was no upper limit as to the turnover. So this was the example, because these things were decided arbitrarily. There was no scientific or there was no judicial report or commissions which laid down, which suggested the parliament or the government of India to do such acts.
Uh, can you please highlight Constitutional Amendment 1, that is first constitutional amendment, with respect to fundamental rights? Like, what was the original text of Article 19, 1A, and how did First Amendment Act made change in it?
Article 19(2) was substituted through First Amendment Act, first Constitutional Amendment Act. Mm. Few new grounds were added. Uh, uh, those grounds were public order. The term reasonable classification, the term reasonable was added in Article Clause 2. Other two grounds were also added. I am unable to recall those grounds right.
Right to property is a fundamental right or a constitutional right or merely a legal right?
Initially, it was a fundamental right under Article 91, but through 44th Amendment, it has been omitted and a new right has been added. A new article has been added as a 308, so which provides right to property to the citizens. So we can say that it is a constitutional right.
Okay, that's all from my side.
Shalabh, so we'll end your interview here.